The relationship between First Peoples and the newcomers here was at one time quite positive. And it was a relationship of equals and of trust and of sharing and of respect, mutual respect. And that's a relationship that arguably doesn't exist between different segments of our society. For me, when we talk about truth and reconciliation, we're really talking about the original spirit and intent of treaties. And to me, we will know that reconciliation is starting to happen in Canada when people of all different backgrounds and creeds and languages and colors are living in mutual respect, because that's the relationship that was envisaged a couple of hundred years ago when the treaty process started. Mississaugas of Alderville First Nation had the misfortune to be involved in a treaty, the Williams Treaty, that is arguably the worst treaty that was ever initialed or enacted, I should say, in Canada. And the history of it has been the source of a book by a woman named Peggy Blair. It's called Lament for a Nation, Lament for a First Nation. And basically, it's considered the worst treaty possibly in Canadian history, because if you believe the outcome of the treaty, you would believe that the people from our First Nation in Alderville and 6 other sister communities gave away in that treaty their rights to hunt and fish and trap, which they had enjoyed since time immemorial. The land sustained them. So it's incredible that by any stretch of the imagination they would ever agree to giving up those rights. But for all sorts of reasons, some of them communication problems, the law of the day allowed government commissioners to prevent lawyers to represent First Nations leaders, and some outright trickery and chicanery resulted in a final document that is still regarded as incredible, and quite literally incredible, and is the primary reason why the Williams Treaties are now wending their way through the court system. They're in the federal court right now, and we suspect and hope that the current judges who listen to the evidence are going to come to the conclusion that the treaty misrepresents what everybody's intention was to achieve in 1923. The rights to harvest in my community in Alderville, rice is a staple that was gathered by my grandparents and their parents and grandparents for centuries. And to be in a position where we feel we have to negotiate for sustenance, the ability to feed ourselves, that's to me a really obvious reason why the treaties need to be looked at in modern terms and perhaps renegotiated. Treaties are the law of the land. Many Canadians aren't aware of this. Section 35(1) of the Constitution Act of Canada, 1982, says that the Aboriginal and treaty rights of Aboriginal peoples are hereby recognized and affirmed. That's as high a law as you can get. In the United States, it's Section 6, and there are descriptions of it as the supreme law of the United States. It's up to future generations, students, researchers, political leaders, to start explaining why they haven't implemented those treaties if they are the supreme law. And there are many reasons. For example, there were laws against segregation. The American Constitution says all men are created equal. But why did it take 200 years for there to be state laws that enacted that on the ground, that gave people voting rights and so there's a political will issue here, but nonetheless, treaties are the law of the land. Treaties have no expiry date. the treaties promises were often said by the people who offered the treaty relationship to us, the Europeans. The promises were to last as long as the rivers run, as long as the grass grows. In some cases, they said as long as the British wear red coats, which they still do. And the promise by Sir William Johnson at the Treaty of Niagara Congress in 1764 was, your people will never be poor as long as the world exists. So there is no expiry date. When people talk about ancient treaties, nobody that has any knowledge or respect for English common law talks about the Magna Carta as an ancient document. It's a document whose principles are still in force. And the third inalienable truth is, I hear people say, well, the problem with these treaties is that they create one set of laws for one group of society and another set of laws for another group. And that happens usually in regard to arguments with regard to hunting and fishing rights. The fact of the matter is, people have to understand that those agreements were made by their ancestors. We are all treaty people. The agreements were thought to be quite reasonable, given that the Indigenous peoples were prepared to share the use of land with newcomers that had been theirs exclusively prior to that for thousands of years, and that each party to these agreements had responsibilities to live up to them.